Arguments against strict liability. In justice, a person may be liable where they are not at fault and have exercised all reasonable care. This offends the natural sense of justice as illustrated in the following cases: Callow v. Tillstone, the butcher was liable despite doing everything possible to have the meat checked out. R v. Howells, the defendant was liable despite being unaware that he required a license and had no intention to use the gun as a weapon. PSGB v. Storquain. The pharmacist had a genuine belief the prescription was valid. Strict liability does not necessarily act as a deterrent. In order to act as a deterrent, a person must have knowledge of what they are doing is wrong before being able to take steps to prevent it. In many cases the defendant is unaware of the circumstances leading to liability. See Callow v. Tillstone, Alphacell v. Woodward, PSGB v. Storquain. Also speeding, which is arguably a crime which is committed more than any other, is one of strict liability. If strict liability was an effective deterrent, then we would have no speeding cars on the roads. Stigma: any criminal offense carries a stigma and needs to be declared for employment purposes. It can cause immense damage to a person's or a business reputation, and therefore proof of fault should always be a requirement in establishing criminal liability.
Law case notes.